Good afternoon. One of the things that we decided about this session was we're going to insist on questions. And we have an armed guard here who's not going to let you out unless you've asked a question, okay? So be careful, make sure you ask good questions because he may not let you out if you don't ask a good question, okay? I'm going to talk about the International Trade Commission, not so much the International Trade Commission itself and how it works, but more a comparison of what is interesting at the International Trade Commission versus the District Court, the two general types of patent litigation in the United States, really in order for people to figure out when I'm looking to litigate, I'm now a plaintiff, I've got a patent, somebody is infringing, I want to enforce it, where should I enforce it? There are good things about the ITC, there are good things about District Court, and this hopefully will help you figure out which is the more interesting place to be. Now, the District Court is the usual place infringement actions take place, and in fact, up until about 10 years ago, although the ITC heard 337 cases, they were very unusual, and the average patent attorney couldn't tell you how an ITC case was run because they had never experienced it. They had heard, yes, such a thing does exist, but they really didn't know about it. A lot of things have happened to change that, where now 337 cases, now when I say ITC, it's under Section 337 of the law, so I may go 337 cases or ITC cases, and excuse me for not being consistent. But 337 cases are much more common. There are all sorts of theories as to why they're more common, but the reality is that they're more common and people are experiencing a lot more. One of the things that people think that makes it more interesting is the speed in which it takes place. Another thing is that it is easier to get an injunction, a limited type of injunction. I'll discuss what kind exactly later on. But it's easier to get that, especially since the Supreme Court has held that in patent litigation in the District Court, injunctions are much more limited. They've got a standard that they put out for patent injunctions that is similar to the standard everywhere else. But since it's harder to get it in the District Court and easier in the ITC, then people prefer the ITC where an injunction is very important. The last point that I think is interesting in terms of why people choose it and why it's become more popular is the fact that you have jury cases in the District Court, whereas in the ITC you're guaranteed a judge. In the District Court, either party requests a jury, the case is a jury case, whereas in the ITC there are no juries. Well, a lot of the times people would say, well, mostly defendants don't want juries. Why would a plaintiff opt for a jurisdiction that doesn't have a jury? And very often it's because I have a very complicated case, and the other side has a very simple case. The odds of my being able to convince a jury and have them understand the nuances that they're going to have to understand in order for me to win are so complicated that I'd rather be in front of a judge where I have more of a chance to have him understand what the issues are all about, especially the ITC judges where a new judge really knows nothing about patent law, but as they progress over a number of years, they become experts in patent law and know it very well. Now, the ITC is not a court. It's an agency of the federal government. It's basically under the president. It's under the executive branch. And it has certain peculiarities because of that. One of the peculiarities, as we'll discuss later, is the president has to review its decisions, and winning in front of the ITC does not automatically mean that you've won. But let's go into some of the basic differences. The first is timing. The ITC, according to statute, must complete the investigation. It's called an investigation, not a litigation, within a certain time frame. And the time frame can be different but usually it's around 18 months for complicated cases. And that is a hard deadline, meaning once the judge or the administrative law judge sets the time for trial, it is rare that that time will change. Whereas in district court, once the judge sets the date for trial, it is rare that that trial actually takes place on that date. There are all sorts of delays and things like that. So the ITC, if you want a decision relatively quickly, and if you want a certainty of when you're going to get a result, the ITC is the place to go. The district court, you could find districts that do things fast. The problem is that as a jurisdiction says they're going to do something fast, they start to have the cases line up, and they very quickly get behind. And if you're filing today, and the expectation is that you will get to trial within 12 months, by the time you actually get to trial is much later because so many people have filed, there's a backlog. Whereas in the ITC, what you see is what you get. When you get a trial date, it's a very hard trial date. Another difference is the multiple defendants. One of the recent changes in the patent law said that if the only relationship between defendants is that they are infringing the same patent, you cannot join them in the same litigation. So you have to file different litigations against each separate infringement. So that means you can file it against the manufacturer and his customers, and you can file a second one against the second manufacturer and his customers. But if they're not related, you have to file these separate lawsuits, whereas 5 years ago, you could file one lawsuit against everybody. And the reason they're doing that is because they wanted to make it more difficult for trolls. One of the things about the ITC is that despite the change in the patent law, you can still sue as many people as you want. We actually had a case which I think is the largest number of respondents. I think we had over 150 respondents in one case. It's unusual, and a lot of them dropped out through settlement and otherwise, but there's nothing to stop you from going after all of these people. Another big difference is really the way things get done. There are three parties to the litigation in the ITC. In the district court, you have a plaintiff and defendant, and you have multiple plaintiffs, multiple defendants, but you basically have two sides. At the ITC, you have a third side. It's called OUII, the Office of Unfair Imports, and they are representing the public in the litigation. Now, as a practical matter, they don't do a lot of advocacy, but what they do is really keep things a little bit honest in discovery. And there's some people who say that when, at the end of the case, when they file their brief and tell the judge, in our opinion, the patent's valid and infringed, there's some people who say that the judges follow that. There's some people who say the judges look at what OUII does and does the opposite. And I think it's a flip of the coin. I think the judges make independent decisions. But what they do is in discovery disputes, they know that the OUII has been more intimately involved, and very often they'll follow OUII's lead. And so what happens is you're supposed to have a conference call with the other side on some regular basis to try and resolve discovery disputes. OUII is generally on that call, and generally the kinds of shenanigans that you face in district court, OUII will try and stop those from taking place. Now, they're not completely successful, but very often when you go to the judge with a problem, he'll look to OUII, and they will tell him, here's what I think, and it is influential in the discovery area. The other is that because of the speed and with which things are happening, and because it's an investigation, your complaint has to be much more detailed than in an average case, and your answer has to be a lot more detailed. So in a federal court, a district court litigation, you basically say, I'm XYZ Corporation, defendant is ABC Corporation, I own the following patents, they make the following products, those products infringe my patents, please give me the following relief. You don't need much information. Whereas in a complaint in the ITC, you've got to detail exactly what the claims are that you think are infringed, exactly what the products are that you think are infringed. You've got to make the comparison of item by item of the elements of the claim to the elements of the product, and you really have to give a detailed analysis to tell them what's going on. You also have to give them a complete analysis of what's called the domestic industry. One of the requirements in the district court, the only requirement or requirements are that the patent be valid and infringed. In the ITC, the patent has to be valid and infringed, and you have to show that there's a domestic industry to protect, with respect to the patent. So the plaintiff gets a lot of time to prepare, and one of the things that often happens is the plaintiff will spend months preparing the case prior to bringing it. All of a sudden, it's sprung on the defendant, who is very surprised and has to constantly play catch-up. Well, that's good and that's bad. It's good because as a plaintiff, you get to prepare, you get to line up your experts, you get to do a lot of things. But in my experience, it's bad because if you're a defendant going to the judge and saying, plaintiff hasn't produced documents to me, you're going to find a hard time explaining to the judge, well, I was surprised, they asked me for stuff I didn't know about, it's taking me time. He's basically going to say, I know you prepared in advance, you should be ready to hand it all over, to stop playing games. Whereas if you're a defendant and the plaintiff is asking for documents, it is usually a good excuse to say, listen, I'm doing things as fast as I can, you got to give me more time to do things. That is an acceptable answer very often. Now, I talked for a bit about those are some of the procedural issues. There's some substantive differences. The biggest substantive difference is the domestic economic industry. There has to be a substantial domestic economic industry involved, which means the object of this whole thing is the International Trade Commission. They are interested in whether there is some foreign activity that is unfairly bothering a domestic U.S. business. So the unfairly part is the patent infringement. The bothering of a U.S. business, that's one of the things you're going to have to prove. You're going to have to prove that, number one, you do have a domestic business. The domestic business is substantial. You're going to have to prove that the activities are affecting, the infringement is affecting that. And you're going to have to prove that the domestic industry is, or at least a good piece of it, is in some way related to the patents in issue. You're going to have to show is not that they are bothering me, not just that they are infringing and they are bothering me, but that the infringement is connected to how they are bothering the domestic U.S. business. And that's called the technical prong. So in order to show a business, and don't forget, the entire business need not be related to the patent. So you have to show, it's called the domestic industry. There's a technical prong and an economic prong. The economic prong says, I've got a business. And normally the way you show that is you show how much you invested in your plants and in your equipment. You show how your labor, I'm employing 600 people, and if this infringement continues, they're going to be out on the street. I've invested so much capital in this whole operation. Or I've exploited the patents. I've licensed that. I am in the business of licensing. Whether or not, everyone's talking about trolls, and there's a whole bunch of case law as to whether trolls can take advantage, which I think is a little too complicated to go into. I could spend the entire 2 hours discussing that. But the issue really is whether or not it is your only business. Do you have a business in exploiting the patents that will be affected if this infringement continues? The technical prong says, okay, now that I've seen the business, is that business somehow related to the patents so that when I say that the business is affected by what the unfair practices are, I can say that the patents are being affected, not just in general he's doing something wrong. I mean, for example, if I've got a phone and I say, okay, well, I want to bar importation of the phone because it's infringing something. Well, what is it infringing? It's infringing, there's one app on the phone that 1 in every 3 million people actually use. But that app is infringing, and I want you to bar the entire phone. Well, it sounds a little bit ridiculous, and it is. What they talk about is the infringement what is effect bothering you? So in other words, if I stop the infringement, you will be just as affected by the import as if I didn't stop the infringement, so that you've got problems with your technical prying. You've got problems showing that it's the infringement that's causing these problems. And very often to show the technical prying, you show that there's some tie in spending to specific patents. I'm spending this money to exploit this invention. This invention is the centerpiece of my patent. R&D. I don't have a product yet, but I have this invention. I'm doing a lot of R&D based upon that invention. My investment in R&D is my business that's being affected. Or engineering. I've got this invention. I'm spending X number of dollars turning the invention into an actual product, and that's what's being affected. Or even licensing of the patents. I've developed a licensing program, and I am exploiting the patents, and that's going to be affected. There's a lot of litigation surrounding what licensing is all about in terms of the economic prong. Now, most of the time, and a lot of these cases revolve around the electronics industry. Well, in the electronics industry, if I've got 500 patents, I'm not going to people in general and saying, here are 3 patents, I want you to license these 3 patents. Very often what I'm doing is I'm saying, I've got a portfolio of 500 that I'm licensing, or I've got a separate sub-portfolio that relates to the X feature, and these 200 relate to that feature, and I'm licensing these 200. So very often, the patents that are in litigation are part of a portfolio, either the entire portfolio or some subset of the portfolio that's being licensed. And the argument is, well, if you're spending $10 trying to license 500 patents, then here are 2 patents in issue. That means, 1/250th of your expenditure is on these 2 patents, and therefore you don't have the requisite business to be protected. Well, obviously, not all patents are created equal. If I'm going out and I'm licensing a portfolio of 500, there are probably a couple of patents that are useless, a couple of patents that are close to useless, a couple of patents that are really valuable, and a couple of patents that are in between. So one of the ways of showing that the domestic industry is a good domestic industry, despite the fact that you're licensing 500 patents, is to say, well, yes, I'm licensing 500 patents, but the key patents to this entire licensing program are these 2 or 3 that are in litigation. And there are a number of ways of showing that. You're not limited in how to show it, but there are a couple of normal ways of showing it. One is obviously how many patents there are versus the portfolio. The other is, are these patents that were specifically discussed in negotiations? For example, if I say, do you want to license my portfolio? And you say, I don't need your portfolio. I'm not infringing anyone. I'd say, yes, you are. For example, take a look at these patents. Well, if these are the patents that you gave as the example as to why they have to license the portfolio, those are obviously more important than the rest of the portfolio. Have these patents been litigated before? Are they, for some reason, pioneer patents? And looking again at the scope of the technology versus the scope of the patent, is this something that is really important? Now, I've sort of discussed the procedural issues, and I've discussed a lot of the substantive issues, but I want to discuss, okay, you've now won at the ITC. What have you won? Okay, and realize the most important thing to realize is you have not won any money, period. You cannot win money at the ITC. What you do win, and you don't win an injunction in the traditional sense of an injunction. What you win is a bar to importation. And the bar to importation, there are various types, but the most frequent type is a bar that says, I want to stop these particular products and products like them from this company. Now, there is another one that says, I want to bar these kinds of products from any company. Historically, that has almost never succeeded, and within the last, 5 years or so, they've made it even more difficult to succeed on that issue. So what you're really doing is you're saying is, these manufacturers, these importers, I want you to stop them from importing these products. Now, you theoretically can bar any product that infringes. As a practical matter, one of the things that the ITC is going to look at is what is the relationship of the infringement to the overall product, and what is the relationship of the infringing element to the overall product. So, for example, if I have a patent that relates to making a computer chip, and the patent allows me to make chips in a certain way which allows it to have certain functions, well, if those functions are critical to a telephone, the odds are I'm going to be able to bar the telephone that has that chip in it. There's enough of a relationship. There's enough of a the infringement is key enough to the product to make it worthwhile to bar the entire product. On the other hand, if I've got a factory that's just putting out these chips, I don't particularly need a good chip, but as long as I've got the factory, I'm going to use the chip in a refrigerator. The lights, the timer in the refrigerator, the controls in the refrigerator all use that chip. And why not bar the refrigerator? Well, because there's nothing particularly, if you look at the chip as an overall relationship to the refrigerator, it just isn't that important to the refrigerator. And therefore, I'm not going to take a huge product that has a minor infringement and bar that from importation. Again, you may get damages in the district court for that, but the ITC is not going to bar it. And so you have that relationship. The other relief you're going to get is if there have been prior imports that are in a warehouse, you can get an injunction against those products being distributed from the warehouse. But usually what it is an importation bar against specific products from specific companies. Now, one of the things I also want to discuss is the decision-making process. In a district court, you have a decider of fact. It could be a judge, it could be a jury, but who make a determination of whether there is infringement, whether the patent is valid. And then you have a judge who basically reviews that decision. The judge will review the decision in terms of, is there enough to support the validity, the infringement? The damages awarded, do they make sense? And the judge will also decide the scope of the injunction. It goes from there to the Federal Circuit. There are those who say the Federal Circuit, that the district court activity is just a tryout for the Federal Circuit. But regardless, the Federal Circuit will review that. The Federal Circuit will come up with its decision. Once in a blue moon, you're going to have the Supreme Court getting involved, but effectively, for most cases, the Federal Circuit is the end of the road. The ITC process is very different. When you have a trial in the ITC, you have the trial in front of an administrative law judge. He is not a judge. At this point, it's all men, so I can say he's not a judge in the sense of the courtroom. He's not what's called an Article III judge. What he is an administrative judge. He does not issue a decision. He issues a recommendation. The recommendation goes to the full ITC, the full commission, who actually makes a decision as to whether to issue an order against importation. Historically, the ITC was a rubber stamp on whatever the ALJ did. Rarely did the ITC even think about what the judge did, let alone reverse the judge. They are getting much more active today in terms of taking, they don't have to take the case, they don't have to take, they can take individual pieces of the case. They have a wide judgment call in terms of what to take. But they can do whatever they want. The other thing that they do that is interesting is they look at the public good. So what they say is well, yes, technically there's an infringement, and yes, this import is damaging your business. But if I stop this import, 50,000 people go out of business. Whereas if I don't, if I continue the import and you suffer, 20 people will go out of business. I'm sorry, but I'm just not going to do it. From a public perspective, I'm not going to put that many people out of business, even though technically you're correct. So they have the ability to weigh the public interest. Assuming they weigh the public interest and they come out with a recommendation that they come out with a decision that there should be a bar to importation, the president gets involved, and the president has 90 days to reject what the ITC did. So realize that at the presidential level and at the ITC level, there's a lot of politics going on. One of the things that people actively do is get in touch with their congressmen, get in touch with their senators, have the congressmen and senators write letters and speak to the people on the ITC. And, I mean, it's not the president himself who makes this decision, but the office, he's sort of given it down to the trade representative to decide. So you talk to people at the trade representative office, you talk to people at the ITC, you bring in your big guns, the senator, you know, we are the biggest employer in your state, come help us, if you're a defendant, come help us protect our business, or if you're the plaintiff, come help us protect our business. These are voters who you are not going to help, and they're going to be put out of business. And then from there, it goes to the Federal Circuit, and again, the Federal Circuit then deals with the same way it would deal with a district court case. And then, again, very rarely does it go to the Supreme Court. But those are the processes that go on. And as I said, we insist on questions, so please, let me have any questions that you've got. Yes?
I hope you can hear me. I've got two questions.
Yes?
One, you talked about this technical probe from domestic industries. Now, my question, do you actually have to have your own proprietary domestic industry? So let's assume that I have that I'm a German company and that there's a new product I would like to bring to the US market. I know that there's a US company also involved in similar products, but I have an improved grade and I'm going to be the first one that is actually going to provide its improved grade. Unfortunately, there are Italians and they would like to bring this product to the US as well, and they would be infringing in the US. Can I then rely on the activity of the US company in order to make it clear that there is domestic interest, even though that domestic interest, those domestic companies, are not owned by me?
The answer is no. You must have a domestic industry.
Okay.
Now, it could be that your domestic industry is through your distributors and things like that, but they've got to be your distributors, your business, not somebody else's.
Okay, I think that answers the second question. If I have indeed sales through my own distribution channel, then that's fine. If it's independent distributors, but so they purchase from the Italians, they purchase from me, they purchase from whoever, Would that also be domestic industry?
It could be. If you said, listen, I have independent reps, but I am their only customer. So they're basically, the fact that they're employees versus non-employees is irrelevant. That could easily be domestic industry. But if there are businesses that sell 50,000 products, one of which is yours, that's not a domestic industry that's going to be affected. Your one product is not going to make or break that company. So even if it could be a domestic industry, it's not going to be counted.
Okay. Then the final question, and then I'll pass it on. And this is a hypothetical one. Let's assume, again, this German company, let's assume that there are military compounds, US military compounds in Germany. If they were to take the product into the site of the Americans, their military compound, is that importation? And can I go to ITC in order to say, well, it happens not just when it is imported into the United States, but the United States extends to its military sites. So this is also importation, be it on German territory.
I don't know. I haven't seen a case like that. I mean, realize that there are maybe 30 or 40 cases a year from the ITC. So I won't tell you there hasn't been a case like that, but I don't know of one. I'm sorry. Yes?
Good evening. I'm a litigating practitioner in India, Lakshmi Kumar and Sridharan. Now, I have a couple of questions, but for the sake of brevity of time, I'll stick to one. I'll probably have a word with you after the presentation. Now, the biggest question that I have, the most important one I have, is a discussion on the scope of the order that the ITC is willing to give. Now, the Indian border enforcement rules, as we call it, is very recent. It's passed in 2007. And this is becoming one of the biggest problems that India faces today. Because under the Indian procedure, you necessarily do not have to implead the manufacturer located outside the country. You can pick any importer you want. But once you pick an importer, say you take consumer goods. We are talking about hundreds and thousands of importers. And you talk about a product like a mobile phone. You may probably going after one manufacturer, and therefore you identify the product based on the brand. Even assuming you get an order in your favor in the ITC saying, okay, brand X, all phones manufactured under the brand X are hereby prohibited from import into the United States. It's very easy for somebody, maybe for an upcoming brand, to rebrand their mobile phones. Or, in the event the order is specifically limited to certain importers or certain manufacturers, and the label that is affixed on the goods that are actually imported, what if I change the brand, change my distribution channel, change my packaging? The circumvention factor, how is that accounted for in the ITC's order?
Well, in the ITC, there's something called a general exclusion order. It's one of the things I said it was very rarely granted. If you can show exactly what you said, which is there's no point in getting a bar to importation against this company for this product because it's going to be changed overnight. All they're going to do is take the factory, they're going to sell the factory to a different company, they're going to make the same thing, they're going to put the label with the trademark on it, they're going to put a new label on, and they're going to go through different distribution systems. What's the point of this injunction, this importation bar? I need a general exclusion order. That's what the general exclusion order is built for, exactly the situation you described. However, it is very difficult to get. Not impossible, but very difficult to get. You've got to really show not only that it could theoretically happen, but you've got to show as a practical matter that it is happening, that it's happened with these companies in the past. It's got to be more than just a theoretical worry about it. You've got to have some hard facts as to why it really is something that you are justifiably concerned about.
Thank you.
Okay. I mean, I realize that the guard, you can't see him, but he's right outside. He'll stop you from leaving without questions. Okay. Thank you very much.